Welcome to Roman Manor. This lesson will explore a subject central to any federal civil procedure class in law school, personal jurisdiction. This overview will introduce the viewer to the basics of PJ. However, we will examine stream of commerce cases in a later lesson. You can also check out the cases this video will reference via the links in the description below. And with that, let's get to it. What is personal jurisdiction? Personal jurisdiction refers to a court's power to exercise its jurisdiction over a particular defendant or property. Like many legal concepts, personal jurisdiction has evolved over the decades. Most CivPro classes begin with Pennoyer v. Neff. The landmark case serves as the concept starting point for the student. The course then introduces the modern articulation of PJ with International Shoe. CivPro classes reference a number of cases to flesh the concept out, but Pennoyer and International Shoe provide the scaffolding upon which other cases are attached to. In addition to PJ, the court must also be able to exercise the appropriate category of subject matter jurisdiction over the defendant or particular property. Further, the lawsuit must be tried in the proper judicial district, a concept known as venue. These concepts are explored in separate lessons. For the purposes of this lesson, we will focus solely on personal jurisdiction. What are the types of PJ a court can exercise? As we've just seen, a court can exercise personal jurisdiction over both persons and property. When the court exercises PJ over a natural person, such as an individual, or a legal person, such as a corporation, it is exercising in personam jurisdiction. When the court exercises PJ over property, it is exercising what's known as in rem jurisdiction. There is a third category, called quasi-in rem jurisdiction. This PJ category is utilized when the court is exercising power over property and that property's owner does not live in the forum state. In other words, the court is unable to exercise in personam jurisdiction over that property owner. This lesson will cover the requirements for in personam jurisdiction. As you can imagine, courts can exercise quite a bit of power. After all, through PJ, it can adjudicate the legal liability of a particular defendant or determine the rights of competing parties to a specific piece of property against all the world. So what limits exist on the court's power to exercise PJ? There are two buckets in which these limitations can be gathered. One contains statutory limitations, the other contains constitutional limitations. We will begin with the statutory limitations. The language composing a jurisdiction's statutory limitations will vary from state to state because each state government is free to create those statutory bases, provided they comply with the constitutional limitations we will examine later in the lesson. But the essence of those limitations will be the same. You may be wondering, if we are dealing with federal civil procedure, then why are we considering state statutes regarding personal jurisdiction? Well, Federal Rule of Civil Procedure Rule 4K states in part that, quote, serving a summons or filing a waiver of service establishes personal jurisdiction over a defendant who is subject to the jurisdiction of a court of general jurisdiction in the state where the district court is located. So because of this aspect of Rule 4, the federal courts must examine whether PJ is appropriate over a defendant as if it was the state court sitting within the federal court's jurisdiction. Now generally, courts have four bases permitting it to exercise PJ in virtually any state. Bases 1, 2, and 3 are sometimes called the traditional bases, and were delineated in Pennoyer. These situations are when 1. The defendant is present in the forum state and he is personally served with process. 2. The defendant is domiciled in the forum state. And 3. The defendant consents to personal jurisdiction. This last one, circumstance 4, is not a traditional basis and will be discussed in more detail below. Nonetheless, if the defendant has committed acts bringing him within the ambit of the forum state's long-arm statutes, the court may exercise PJ over him. Obviously, there's a bit to unpack here, so let's examine each of these four situations in detail. The first of the traditional bases that can be exercised to support PJ is when the defendant is physically present within the forum state and is properly served with personal process. Proper service of process has several requirements. 1. The person serving the defendant cannot be a party to the suit. 2. that person is at least 18 years of age, and 3. That person presents the defendant with a copy of the plaintiff's complaint and summons. As an aside, service of process is a lesson all on its own and will be discussed at a later time. Okay, let's move on to the second of the traditional bases. The second of the traditional bases that can be exercised to support PJ is when the defendant is domiciled within the forum state. Domicile refers to where a person's permanent residence is or where that person intends to make their permanent home. In essence, where a person is domiciled is a question of geography and their intent. This can be easy and sometimes complicated, but for the most part, simply look to where the defendant lives, or if the person is in the process of moving from one state to another. Usually, the domicile of that person will be the state they just left, as the new one will not become their domicile until they have completed their move into their new state. If these requirements are met, then the court can exercise PJ over the defendant on this basis. Okay, let's take a look at the third traditional basis for personal jurisdiction. The third and last of the traditional bases that can be exercised to support PJ is when the defendant consents to the court's doing so. The defendant's consent can be shown in several ways. One way this can be done is expressly, such as when a person agrees to a forum selection clause in a contract, or when a non-resident appoints an agent for service of process in the forum state. Another way a defendant can consent to PJ is through implied consent. This aspect of PJ was clarified in 1927 in a U.S. Supreme Court case titled Hess v. Pulowski. In that case, the court upheld a Massachusetts law permitting Massachusetts-based plaintiffs involved in car accidents with non-residents to serve process upon the Commonwealth's Registrar of Motor Vehicles in lieu of personally serving the non-resident defendant. In essence, the court held that non-resident drivers had impliedly consented to the Massachusetts law when they entered the jurisdiction in an automobile. Lastly, if a defendant makes a voluntary appearance in the forum state, they will be held to have consented to that court's jurisdiction. A voluntary appearance is made when a defendant comes to court to deny the allegations made in the plaintiff's complaint. However, most states permit what's called a special appearance. This allows the defendant to appear within the forum state and in court to contest that court's ability to exercise PJ over him without that appearance being equated with consent to the court's personal jurisdiction. So, how can a court exercise PJ over a defendant if none of the previously mentioned circumstances present themselves? In that case, the court must look to the forum state's long-arm statute. These statutes exist to provide the court a basis by which it can exercise personal jurisdiction when there are no other bases to do so. A limited or specific long-arm statute will set out the elements necessary for the court to exercise PJ over a defendant. However, in many states, these statutes are quite broad and are called unlimited long-arm statutes. For example, in California, its long-arm statute reaches the constitutional limit. What this means is that a California court may exercise PJ over a defendant so long as its exercise does not run contrary to the Constitution. And with that, we've concluded our survey of the statutory limitations imposed on personal jurisdiction. We will now turn to that second bucket containing the constitutional limitations in the court's exercise of PJ. Once a state can exercise one of the four statutory bases for PJ, the question then becomes, will the exercise of that personal jurisdiction be constitutional? Modernly, a court may exercise personal jurisdiction if three factors can be sufficiently demonstrated. In 1945, in the landmark case International Shoe Company v. Washington, the U.S. Supreme Court developed the minimum contacts test. It is composed of three factors: contacts, relatedness, and fairness. Keep in mind, there are really two things the court will be looking for. One, the constitutional factors we just mentioned, and two, whether the defendant had proper notice. Obviously, there's a bit more to it than that, and each of these three factors has its own constituent parts to consider. So let's dig a little deeper and take a look at each. The minimum contacts test laid out in International Shoe requires that the defendant have minimum contacts with the forum state, such that the court's exercise of personal jurisdiction would not offend traditional notions of fair play and substantial justice. It's a somewhat ambiguous maxim, but whether the defendant has minimum contacts can be determined by two factors. One, whether the defendant purposefully availed himself of the forum state's laws and the protections of its courts, and two, whether, from the defendant's perspective, it was foreseeable that from those contacts he could be hailed into the forum state's courts. As an aside, the word hailed is just an anachronistic way to say hauled into or brought into court. Purposeful availment refers to whether the defendant's contacts with the forum state were done purposefully or intentionally. This is a fact-focused analysis. When deciding whether the defendant purposefully availed himself of the forum state, we can look to the 1958 U.S. Supreme Court case Hansen v. Denkla. In that case, the court tells us that, whatever the defendant's contacts with the forum state are, we must find that he purposefully availed himself of the privilege of conducting activities within the forum state, thus invoking the benefits and protections of its laws. If our analysis tells us that this is the case, then we can start to look at foreseeability. As a quick aside, I mentioned in the introduction that there are some unique aspects to purposeful availment regarding corporations and stream of commerce cases. This will be discussed at length in a separate lesson. That said, let's move on to the next factor affecting minimum contacts, foreseeability. International Shoe's minimum contacts test also requires that the defendant's activities in the forum state be such that it is foreseeable he could be hailed into court there. As we've touched on already, the phrase hailed into court is an outdated way of saying brought into or hauled into court. In essence, this second plank of the contacts factor asks whether, from the standpoint of the defendant's activities in the forum state, it would appear likely that he could be brought into court in the forum state if the circumstances necessitating it arose. Relatedness looks to whether and to what degree the defendant's activities in the forum state are sufficiently related to the plaintiff's claim against him. This concept can be further broken down into specific jurisdiction and general jurisdiction. We will take a look at each of these. So what is specific jurisdiction? A court will have specific jurisdiction over a defendant if the plaintiff's cause of action results from the defendant's acts committed in the forum state. In contrast, a court will have general jurisdiction over a defendant if the defendant is at home in the jurisdiction. This requires that the individual be domiciled in the forum state. But how do these concepts relate to the defendant's contacts? This chart, what I call the spectrum of relatedness, illustrates the jurisdictional consequences resulting from the character of the defendant's act or acts within the forum state. How the defendant's contacts with the forum state are characterized determines where on the spectrum they will lie, and whether the court will lack jurisdiction, have specific jurisdiction, or have general jurisdiction. If a defendant has no contacts with the forum state, then a court is unable to exercise PJ over him. However, a defendant could consent to personal jurisdiction under these circumstances. The same jurisdictional consequences exist if the plaintiff's cause of action resulted from the defendant's casual or isolated contacts with the forum state. In that case, a court is unable to exercise PJ over him, but as with no contacts, if the defendant consents to the court's exercise of personal jurisdiction, then the court may do so. If the plaintiff's cause of action resulted from the defendant's single act within the forum state, then the court may exercise personal jurisdiction over him. McGee v. International Insurance Company articulated this point in 1957. In that case, the court upheld a California court's exercise of PJ over a Texas insurance company that contracted with a California resident. This was only a single instance. Only one contract was entered into by this Texas company with a California resident, but this single act was found to be sufficient to sustain PJ by the California court. If the plaintiff's cause of action results from the defendant's continuous but limited acts within the forum state, then the court may exercise PJ over him. Burger King Corporation v. Rudzowitz made this point clear in 1985. In Burger King, the defendant, a Michigan-based businessman, refused to recognize the Florida court's PJ over him despite the presence of a forum selection clause in that contract that he had with the fast food company. However, the U.S. Supreme Court found that Rudzowitz's activities with Burger King, and therefore Florida, could be characterized as continuous but limited and were therefore sufficient for Florida to exercise PJ over him. If the plaintiff's cause of action results from the defendant's substantial or pervasive contacts with the forum state, then the court may exercise PJ over him. Perhaps the most relevant case affecting activities on this part of the spectrum is Goodyear, a 2011 Supreme Court case that, in dicta, stated that corporations are subject to general in personam jurisdiction in the states in which they are incorporated and the one state constituting its principal place of business. We will examine this more in a later lesson. Now that we've covered the first two factors regarding the constitutional limitations on PJ, let's push on to the third and last, fairness. As with the two previous factors, fairness is actually composed of several smaller subfactors. These are 1. Convenience, 2. The interest of the forum state, and 3. Other factors related to the litigation at issue. Regarding convenience, defendants often argue that the forum is inconvenient for them to defend their case. In 1985, the U.S. Supreme Court stated in Burger King that the jurisdictional rules may not be employed in such a way as to make litigation so gravely difficult and inconvenient that a party is at a severe disadvantage in comparison to his opponent. However, this seems to be a high bar to prove. Regarding the interest of the forum state, this analysis is fact-intensive. When assessing it, try to place yourself in the shoes of the forum state itself. Ask, if you were that state, would you find any interest in pursuing the litigation before you? Other factors affecting litigation is a catch-all and will be specific to the litigation before the court. In essence, if there are good reasons why the court should exercise its personal jurisdiction over the defendant, but those reasons do not easily fit under convenience or in the interest of the forum state, they should be considered here. Okay, we've covered the constitutional limitations. Now we can examine the requirement that the defendant have proper notice of the plaintiff's suit. As we've said, in addition to having a constitutionally permissible statutory basis for PJ, the defendant must also have proper notice of the plaintiff's suit. Now, when I discussed the first of the traditional bases for PJ, I mentioned that proper service deserves a lesson of its own, and I recommend that you check it out. But for the purposes of this lesson, let's briefly mention the requirements for personal service. 1. The person serving the defendant is not a party to the suit. 2. That person is at least 18 years of age. And 3. That person presents the defendant with a copy of the plaintiff's complaint and summons. Alright, so we've covered a lot, but let's sum it all up. Personal jurisdiction will exist and is properly exercised when the court has a statutory basis upon which to base personal jurisdiction. That statutory basis can be exercised in accord with the Constitution, and the defendant has been given sufficient notice of the plaintiff's suit against him. That's it for this lesson. If you found it helpful, give the video a like and subscribe to the channel. Leave some comments below and check back often for more content. As always, thank you for visiting Roman Manor and have a lovely day.